Welcome to Copyright Law. This is the first lecture. I'm going to keep this week light to make sure people are registered for the class, kind of get your materials, be familiar with the syllabus. If you haven't had a chance to look at the syllabus, please do so. You are going to see we won't get to the particulars of copyright law for a couple weeks. I believe we have to kind of review intellectual property or give you an overview of intellectual property so you know where copyrights fall. It is a type of intellectual property, and there are several different types. So I want to do an overview of intellectual property. I want to give you an overview of the legal system for when we talk about specific cases. You can understand how something gets to court and gets worked out relative to copyrights. And I want to give you a sneak peek, a little background on the other types of intellectual property before we actually delve into the specific details of copyright law, because you'll have to be able to distinguish between the two, what makes something a copyright protected versus a trademark protection. So without further ado, we're going to jump into intellectual property. What is intellectual property? There's my definition. It is the product of the inventive and creative activity of the human mind. You may not be aware of it, but we are literally surrounded by intellectual property every day, right? Think about it. There's music that's copyrighted. We pass signs and billboards and logos. Those are all trademarks. We use patent devices, your cell phone, your computer, your microwave, your TV, your food processor. Maybe you take an aspirin or you're on a prescription medication, falls under patent. Types of, if you use Google to do your internet research, their algorithm is a trade secret. Trade secrets can apply to databases, customer lists. So their intellectual property is kind of our foundation of advanced technology, communication, entertainment, the entertainment industry. What do intellectual property rights do? What do? They allow creators, inventors, artists, entrepreneurs to devote the necessary resources to research, develop, and market creative works and new technologies and consumer products. We'll talk about what would happen if we didn't have rights. Actually, I'm going to do that right now. So what would happen if we didn't have these rights or protections? What if they didn't exist? Where would we be? Would people create? Would people invent? Do you think protections are necessary? Some folks create just to create, and they put it out there in something called the public domain for everyone to see and use and such, and we'll talk about the public domain. But folks do this to make money, right? To advance their business. If we didn't have rights, guess what? It'd be stolen. Do things get stolen? Sure, they do. There's people who pirate music and movies and so forth. But intellectual property rights tend to curb that. Do you think rights and protections are necessary? I hope you're shaking your head. Yes, but some folks think, hey, it should be free for the taking, free to expand on, which in some instances it is okay to do. Economic importance. This is a reason to have intellectual property rights. What do you think is the overall economic importance of intellectual property? Every business uses some form of intellectual property, right? In some instances, it plays a key role in the life of the business, serving as their core asset. I'm sure Google's algorithm is the driving force about how popular they are as a search engine. Coca-Cola's formula for its soda is a trade secret. The WD-40 compound substance, whatever it is a trade secret. business uses, right? What else do we have some economic importance here? A more mature business will focus on defending its IP so they can maintain their market share, remain competitive in pursuing future innovations. The biggest one that there's tons of them that do that actively enforce and defend, the music industry, Disney. Those two are constantly suing infringers. And just to give you an example, they just don't pick out, big money folks to shut down. Disney, for example, went after a daycare in the Orlando area because they were using Mickey Mouse on the wall and their characters on their wall in their daycare. So they certainly actively spend money to defend. Intellectual property is growing internationally. We have this internet that puts all these intellectual properties out there for the world to see and have. There's a ton of money in licensing intellectual property. The total value of intellectual property assets has been estimated to account for one-third of the value of all of the United States businesses. What that means, it represents 45%, almost half of the U.S. gross domestic product. This is a big business. So what do you think is the biggest problem? The biggest problem. The thorn. Rapid advancements in information technology, widespread use of the internet has created reproduction easy and disseminate information easy, and it's inexpensive to reproduce and to send it out and make it accessible anywhere in the world. Intellectual property theft costs U.S. businesses approximately $250 billion in lost revenue and hundreds of thousands of dollars in jobs each year. Trafficking in pirated, counterfeit merchandise, billions of losses in U.S. sales businesses. As technology advances, obviously these things get better. And of course, this is only going to worsen, right? Worsen the loss. Can anyone think of an upcoming technology advancement that's just starting to become affordable to consumers? It made a big presence here during the beginning stages of the coronavirus, right? 3D printers. People at home were making masks for nurses and hospital staff. Can you imagine what that is going to do when it's a little bit more advanced? If you're not familiar with 3D printers, it can make an expanding variety of physical products based on a digital design that you feed it. Basically, when something becomes more common and affordable, it will be possible to download a design file and reproduce a product that might be protected by copyright law or even trademark law or even patent law. So, to fully appreciate these developments, we have to discuss the nature of intellectual property and the reasons why it is protected. So what is intellectual property? We kind of already defined that at the beginning, right? The product of the inventive and creative activity of the human mind. I like that definition, but I think we got to talk about property. What is property? It's about ownership, something that's owned. Real property. We have real property, we have personal property. Real property is land and structures like houses and buildings attached to that land. Personal property is, I like to say, everything else. Could constitute your car, your cell phone, your clothes. And what do these things have in common? What do these things have in common? They're tangible. They're physical. Even your home is physical. You can see it. right? The owner of property owns these rights. You own these rights in these pieces of property, okay? And you can control these pieces of property. What can you do with them? Well, you got your laptop, you don't want it anymore, you could sell it. You can trade it. You can destroy it. If it's a car, you can drive it, right? You can use it. So you can use them as some sort of security, like your home. You could take a loan against if you own it. You can give it away upon your death, right? Most importantly, you can let somebody use it, and you can also exclude people from using it. We'll go over this in a little bit. So this is personal property. I want to talk about intellectual property. Intangible rights. So these are tangible. These things you can do, okay? You do with your personal, tangible property. Intangible property rights. What do I mean by that? These are products that result from our creative and inventive activities of the human mind, right? We can't touch them. We can't handle them in any way. They're just embodied in something. You might say, well, I got the book, I'm holding my book. But the book isn't the copyrighted material. That's just the compartment or the holding facility. The is where you store it, is where you're storing your intellectual property. But it is all in your mind and put down in that tangible form. And like your real and personal property, you can sell it, and you can lease it, and you can exclude use, and you can allow use, even though it's intangible, okay? Like I said, it might be embodied in something that's tangible or some perceptible form or object. Example, a trademark. Trademark may be a word or a symbol on a label, but the intellectual property protects that intangible itself, not the tangible form or object in which it's recorded or expressed, okay? Musical composition is protected, not the CD it was recorded on. If it's confidential information itself that is protected, it's not the server on which it is stored, like a trade secret, right? Follow? All right, I'm going to break this down even further. Private property rights. Let's talk about land, okay? Private property rights we're going to talk about the real property, personal property, private property rights with tangible property. When we have private property rights, we prevent the occurrence that's known as tragedy of the commons, okay? And I'm going to give you an illustration about what can go wrong if private property rights didn't exist, okay? Because we have rights relative to our real property and personal property. I just kind of gave you the background. Your right to use, sell, exclude people, destroy them. But let's take if we didn't have those property rights. Suppose there is a pasture that is open to all cattle owners and where all cattle can graze freely. Each cattle owner would be motivated out of self-interest to bring as many cattle as possible onto the land because there is no cost in doing so. So what happens? What happens? Doesn't last forever. The pasture will be depleted of the vegetation due to the overgrazing and then become useless. However, if only one owner owns the right to exclude others from the land, he will have incentive to preserve it by limiting the access or preventing of overuse. So you kind of have an overuse problem if you cannot control private rights, private property rights. So tangible property can only be used or possessed by one owner or one set of owners at a time. While one person is driving a car, no one else can drive it at the same time, right? We can agree to that. Therefore, these products are called excludable, rivalrous and excludable. And before I forget, there isn't the book that I'm using for this course for supplemental material for you to review. We haven't delved into copyright yet. However, it does talk about this concept in the introduction to copyright. So I'm not going to revisit it in the introduction to copyright. So if you want to take a look and review this section a little over, you can find it in that area. So tangible property, rivalrous and excludable. It means one owner or one set of owners can exclude others. Okay? You can exclude your drivers. What can you do? You can lock it up, you can store it, and you can do that, right? What's the only way you can acquire a vehicle? You buy it, or unless it's given to you as a gift. That's it, right? Well, I guess you can steal it, but that would be against the law. But rightfully so, tangible property can only be used or possessed by one owner or one set of owner at a time, right? Only one person can drive a car, only one person can use your laptop at a time, and you can prevent others from using those things. By contrast, our intangible property, which is non-rivalrous and non-excludable. And what this means is that works can be used by multiple persons at the same time without reducing its supply, i.e. non-rivalrous. One person viewing of a painting. Let's take one person looking at a painting. Does that prevent others from viewing it at the same time? No. You're looking at a painting on the wall. 20 other people can come up and look at the same painting on the wall. It also doesn't reduce the value of the painting or the number of times it can be viewed afterwards, right? Unlike the pasture with continuous use. Once created or invented, an intellectual property work can be easily replicated. The painting can be copied at little cost compared to the initial effort and expense involved in creating it. Take for another example, refer to a specific trademark in making a purchasing decision. Does it prevent others from doing the same? You like Nike brand, but does that stop me from buying the same thing? No. Doesn't diminish the distinctiveness of the brand either. Non-excludable. What do you think that means? That intellectual properties are non-excludable, meaning what? You can't exclude others. It's expensive and impossible to prevent others from using or copying, right? So we kind of analogize this with public goods, something that we are all very familiar with. I'm going to give you an example of public goods. Goods that are not, here's the definition, goods that are not diminished or deleted when consumed by one person, and that cannot easily be excluded from use of others. So think about something in the public goods that aren't diminished with overuse or deleted when one person has it and nobody else can be excluded from using it. Law enforcement, right? We all have equal access to law enforcement and not one person can be excluded from using it. National defense, radio and TV broadcasts, right? Information can't be depleted with overuse, and it's very hard to exclude people. So our intellectual property is non-rivalrous and non-excludable. It's very similar, comparable to public goods, which leads us to why we need protection, legal protection of intellectual property. Intellectual property rights and laws allow these inventors and artists to control their product and works and to fence off the rewriters or those who want to steal their work. Okay? Does this give them a monopoly? Does this give you monopoly? You create a song, nobody else can create a song? No. You know, an owner of a let's say patent on a drug that's used to treat a particular disease has exclusive rights to make and sell the drug. And an owner of a copyrighted photograph of a sunset has the exclusive rights to reproduce and display that photo. That's where they're protected. That's their monopoly of that protected product itself. What it doesn't exclude is similar products from competing in the same market, if they do not infringe on the IP rights. Like, you couldn't steal the drug patent, but you can develop your own drug that treats that same disease. You can create your own photograph of a sunset. So others are free to make drugs to treat the disease or to create photos of the same sunset. There's also another little thing here that works to their, you could say, benefit or detriment, whatever point of view you're looking from. Durations. We're going to talk about limitations and durations on intellectual property rights. There's only one, when we talk about them specifically, that could have the potential of lasting forever, maybe two, lasting forever. But there are, these rights are granted to inventors, i.e., and when I say inventors, patents, creators, copyrights, that are not absolute, because there is a limited duration. And then those things fall into this, we'll call it public domain, and other people are free to use it or to expand on it. Trade secrets are one of those things that could remain a secret indefinitely. Think about Coke products. They've been around forever, and their products are protected by trade secrets. Trademarks can continue to have theirs as long as they continue to register. And we'll talk specifically about those. But what I'm saying with duration limits, it also limits the protections that one has. So the last point on the nature of intellectual property is that they are territorial. What do I mean by that? They are territorial. They are granted by national governments. Each set of rights applies only within the borders of the country that those rights have been recognized. We do have international treaties that exist relative to the copyright. We're going to talk about the Berne Convention, and we're really going to explore how these copyrights get, I'm going to use the phrase, gummed up with formalities, because there are certain formalities and registrations that you go through to protect your copyright in the United States, but if you want to take it out of the United States and distribute it worldwide, you have to follow the rules governing and the formalities governing those countries you want to be in. And early on, way early on, we'll talk about it when we're talking about duration of formalities, is, famous British authors, their works were stolen and brought to the United States and distributed for free, because there's no law against doing that. They would have to have registered properly. It was created in another country, which made it free for the taking in the United States. Lord of the Rings was in the public domain for a while, and we'll talk about that case, because it's not in the public domain anymore, but because it was created in a different country, it made its way here, didn't comply with the formalities of the United States copyright laws, so it found itself in the public domain and then subject to a big lawsuit that we'll talk about a little later in the semester. So, without further ado, I think we need to talk about the 5 principal categories of these intellectual property rights. They come in the form of trade secrets, patents, trademarks, the right of publicity, and of course, copyright. And I'm going to give you a little snapshot of each one. Trade secrets. Trade secrets grants protection to confidential, and I have it in bold, business information. Trade secret law grants protection to confidential business information. So the trade secret is any form of, one, information that, two, has an economic value from not being generally known, two, or ascertainable to proper means, by proper means of another. So you can't be able to acquire it very easily, and it's not generally known. And three, has been subject of reasonable efforts by the owner to maintain its secrecy. That's all we're going to talk about right now. I'm going to expand on it a little bit more so we can compare it with copyrights. But trade secrets is granted protection to confidential businesses, and it is governed by state law. And when we talk about the legal system, you'll hopefully understand what I mean by that, and I'll keep referring to it throughout the semester, what type of law applies, whether it's state law or federal law, etc. Then we have patents, and they protect the new and used technology inventions, and they must be granted the right from the U.S. government. So it protects new and used technological inventions. And to qualify for one, the invention must meet four requirements. The type of subject matter that may be patented, and there's a list, and we'll briefly snapshot patents as well. It must be useful, must be novel, and it must be non-obvious. And when we talk about patents a little bit more, a couple weeks, I'll explain what each one of those means, and hopefully by the end of that, and at the end of the course, you'll be able to distinguish what's a patent, what's a copyright. Like I said, the law is governed, the law is governed by the federal law, and this is the only intellectual property where the government must give you that right. You don't just get a patent because you made something. You got to ask for a patent from the government and be granted one. Trademark. Probably more familiar with the trademark. The identity, it identifies the origin or source of a good or service. It can be a word, could be a phrase, could be a symbol, design, or a combination of words, phrases, or symbols. There's also this concept of trade dress that falls under a trademark, and that protects the form of a product's design or packaging, like the Coke bottles. Over time, I'll show you a number of examples when we talk about trade secrets. And trademarks are governed by both state and federal law. So we have two laws that would govern trademark. Then we have our right of publicity. And our right of publicity is the exclusive rights for prominent individuals to control the commercial exploitation of their identity, right? This is for entertainers or athletes, our models. For instance, you would not be able to use Michael Jordan's image to sell your product, promote your website without his permission, because he has the right of publicity. Using his identity is very expensive to use, but it's also his right to put out there when endorsing product, right? So that's the right of publicity. This is strictly governed by state law. And then we have copyright law, which is, and we're going to spend lots of time talking about copyright law. It grants a set of exclusive rights to authors as to the ownership and use of their creative works. Okay, the work must be recorded or preserved in some stable physical form and must be original. And we are going to break down all of the concepts involving copyright. And when I say author you kind of associate with like a writer of a book. Author is anyone who creates any sort of creative work. Could be a sculpture, could be a photograph, could be a song. And when we talk about copyrights, and I'll repeat this when we delve into it, and I'm going to show you the various categories that can be protected by copyright. For purposes of this class, my examples are going to stick to what we know. I'm going to use movies and music and photographs and books and maybe a play, movies if I didn't say that already. I'm not going to pick some obscure computer software hidden in a database, but we're just going to keep it simple. The laws can be confusing as it is. We're going to keep our subject matter fairly reasonable when we're going through, and easy when we're going through examples too, because the most important part of this is to be able to apply and recognize the law. So these are the 5 rights, intellectual property rights. And after we cover the legal system, I'm going to do a week's worth of quick overview of the other 4, and then by week 3 we'll be jumping into public domain, talking about the public domain and the introduction to copyright law. Okay? Some rationales for intellectual property. Why should we have these rights? Is there any philosophical justification for these rights? There's 3 that have more commonly been accepted for justifications. I think these might also be in the book in the intro chapter if you want to take a look. We have the natural rights theory, the personhood theory, utilitarianism theory, and I'll go through each one right now. For the natural rights theory, the general gist is you think of the intellectual property as a reward. Every person possesses certain inherent rights, which are derived from nature rather than granted by the government. What natural rights do we have? The right to life, right to liberty, and a right to ownership of property that no government can justly deny. That's actually in the Constitution. Those who expend their labor, they're entitled to a reward in the form of property rights. Property rights in the products of their efforts. Okay, and there was this English philosopher, John Locke. If you're familiar with our John Locke from SUNY, not that John Locke, but he is a great philosopher too. Different John Locke. He articulated this theory. His belief was that a person acquires property rights by combing his or her labor with something in nature. Labor is a productive activity because it creates value through the improvement of nature. Property rights are the reward for the labor because the person has a natural right to own the fruits of his work. And as it applies to intellectual property rights, what do you think? Those apply their creative and inventive efforts in producing intellectual property works deserve a property interest in the products of their efforts. So pretty straightforward. You create something, and because you have the right to ownership of property, you're entitled to the natural rights that flow from the works of the fruits of your work. So that's how the natural rights theory works. The personhood theory, or the moral right theory, that is intellectual property as a personality. So think personality or moral right, okay? The personhood extends from the person. And philosopher George Hegel, who created this theory, one develops as a person by interacting with and exercising control over his external environment with other people. Like they exercise control over his external environment as he's working with others. Property ownership is a means of exercising such control because it reflects the acknowledgement by others of something that uniquely belongs to its owner. So, as such, the property is bound up with its owner's identity and individual dignity because it serves an important role in defining him as a person. So based on this theory, intellectual property is necessary so that inventors and creators can have access and control over their works in order to exercise the full extent of their autonomy. Okay? Intellectual activity involves an investment and expression of personality. Since property embodies the person, the product of intellectual effort is the extension of the inventor's or creator's person. So because intellectual property works are considered to be an extension of the person, inventors and creators should be able to retain control over the use of works through property rights. So or actually there's an or this where we tie in our moral rights, or one has a right to claim ownership of his person because creation of an intellectual work involves an investment of oneself. The creator has a moral right to claim ownership of the work since it is a manifestation or extension of his or her person. So our personhood, think extension of person, and how others identify that person by your creative works. Okay? And then our last theory, utilitarianism, where intellectual property is an incentive. And this is the most popular view in the United States. The social utility, the usefulness of an act must be judged by its consequences in terms of its net benefit to society. What's the society going to get out of this? What's their benefit? So benefits of any action must be balanced against the cost to society. Incentive and creative activity requires an investment of resources, but individuals will not invest. The theory is, but individuals will not invest in such an activity unless the anticipated return on their investment is likely to exceed the cost. Well, that sounds very like United States, doesn't it? We're not creating just to create. We're recreating to get something out of it that also benefits society. Without legal protection, those who produce would incur losses because of, free riders and those who want to steal. So the rights allow owners to control their works, and therefore they have a greater incentive to invest in creating and incur the expense, and this leads to improvement in the welfare of the society as a whole. And this is the primary rational theory in the United States, and it's actually codified in the Constitution. This is and I will revisit this along the way in the next couple sections, this is where this section of the U.S. Constitution is what gives Congress its power to regulate patents and copyrights. I will tell you there's another section of the Constitution that allows it to regulate trademark. We'll get there. But this is where that theory comes from, and this is where Congress has the ability to control and regulate and pass laws regarding patents and copyrights. It's Article 1, Section 8 that provides that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And we're going to be circling back to this provision, especially during the duration, when we're talking about copyright duration, because every time the duration gets extended for a copyright, there's lots of challenges of whether or not this is constitutional for them to do. So that is the end of the introduction to intellectual property. Next, there's a couple assignments linked to this week. Going to keep it light though, and we will be ready to jump in with the American legal system next week.